Applying for a green card comes with its own ups and downs. Some go through with a breeze, especially if they hired a good attorney, but others jump through hoops for their green card, and some even get denied. But that isn't the end, fortunately. There are options for you if your case initially gets denied. Hi, my name is Andre Major, immigration attorney and an immigrant myself. Our tip of the week gives you the most common reasons why green card applications are denied and the options you can take to still get your green card. Before I begin, please click the subscribe button and hit the notification bell for you to get updates on our new content. Also, if you don't mind, leave a comment below about your thoughts and ideas about today's topic, or check out our other videos. Before discussing what to do if your green card is denied, let me first explain why your green card applications are denied in the first place. The main reason might be an obvious one, but failure to submit supporting documents. Every application is a story. Knowing how to present your story is the most important part of any immigration application, whether it's a fiancé visa, a family-based application, or citizenship. Proving that the relationship is legitimate is crucial. That requires first understanding the requirements for the application. Then consider any facts that could disqualify you. You then need to explain what happened and why you deserve the outcome you're asking for. For example, deciding whether to file for a fiancé visa versus a marriage-based application, each has different requirements, a story. You then need to document that story. A second common cause for denial is criminal convictions. If you've been convicted of certain types of crimes, such as those that are crimes of moral turpitude, drug trafficking, fraud, or money laundering, or are coming to the U.S. to commit them, your green card could be denied. In most cases, it's the criminal conviction of the foreign immigrant that could disqualify her. However, if petitioner, who must be a U.S. citizen or lawful permanent resident, was convicted of an offense involving sexual abuse of a minor, that could also result in a denial of the petition. A third reason has recently gained increased importance is health-related concerns. Every applicant will be subjected to a medical examination by an authorized medical professional, doctor. Take note that the findings may result in the refusal of your green card. The U.S. government has the authority to refuse a green card application to someone who has a communicable disease, a serious mental or physical disorder, or infections that pose a risk to public safety. Historically, drug use has been a problem, but recently, not receiving needed vaccinations or not receiving vaccinations like for COVID have become a problem for some. Refusing or being unable to have them done before your green card application can be approved will result in the application being denied unless you receive a waiver. A fourth reason for denial of your green card is financial reasons, public charge. If USCIS determines that you will be reliant on the U.S. government for long-term care or financial assistance, your green card application can be denied. Remember, USCIS will have to consider many variables such as your age, health, family situation, assets, and liabilities when you file. A fifth reason for green card denial are more technical to note. For example, you don't satisfy the application requirements. You didn't tell a good story. You don't show up for appointments or interviews. You changed employment after filing an I-140, or you divorced after your spouse filed an I-130, or denial due to an error made by immigration decision makers. Those happen too. Keep in mind, these are only the most typical reasons your application may be denied. Ask questions if you don't understand something or have other concerns. In this way, you'll be more prepared for your application. Now, what to do if your green card application is denied? Receiving a denial is like being stabbed in the heart because you've already committed your money, your time, and effort to meet the requirements. However, don't be discouraged since there are ways to obtain a green card even after you've been denied. Tip number 1, reapply for a new petition. Most people will choose to appeal the decision, but they are unaware that it is often expensive and very time-consuming to appeal. An appeal can take years. I often step in to fix applications that were done without an attorney or with an incompetent attorney. These applications are often missing key pieces of the story. Rather than appealing decision, I often just reapply and cure the defects in the application. A defective application shouldn't be approved. An appeal won't necessarily change the outcome. You got to change the application. Sometimes you have to take a step back before moving forward. Tip 2, appeal a decision. Sometimes an appeal is the only option because you no longer qualify to file a new application. For example, if a child has aged out by turning 21, if that application is approved, the law could treat your child as under 21 because the time is frozen when the application is made. But that won't happen if you file a new petition after your child turned 21. In those cases, you have no choice but to appeal. The denial notice will tell you if and when you can appeal. The disadvantage of appealing your application is that you will only have a limited time to do so. Immigration will charge you an additional fee, and appeals take years. Tip number 3, consider a motion to reconsider or reopen. These two motions are frequently used when you need to correct the record in the case you think USCIS made an obvious mistake. I often do this when we plan on appealing, but I didn't prepare the underlying application. Someone else did. The difficulty is you often do not have enough time to file a proper motion to reconsider or reopen, and you are thus left with only the first two options. The motion to reconsider is filed when you believe the officer denied your case for the wrong reason, such as believing that USCIS misread the law, did not apply the law appropriately to you, or misconstrued your situation. On the other hand, if there's new evidence that might be useful in your case, or if circumstances have significantly changed, a motion to reopen could be your option. Remember, you should be responsible for your green card application. Take the necessary steps, diligently follow the instructions, and provide the necessary evidence. If your application gets denied, don't fret. You can seek the help of an immigration lawyer to expertly assist you through the process and alternative options for your case. Just keep in mind, it might be more expensive to fix a mistake than it had been to do it right the first time. If you find this video informative, like and share it with your friends who are also applying or are thinking of getting their green card. And if you have any ideas for future videos or would like me to talk about a particular immigration-related topic, go ahead and let me know in the comments section below. Until next time, stay healthy and be safe.